Hello and welcome to this Sharpe Pritchard webinar called Executing Your Documents by Virtual Means. My name's Deborah Down and I'm a Senior Associate with the firm. Just a reminder there that we are primarily a public sector firm, so this webinar concentrates on public authorities executing their documents by virtual means. I almost exclusively advise local authorities, so this is the focus of this webinar. However, it also does touch on the requirements for companies because many local authorities execute primarily using companies. So just to give some context to the law on electronic execution, there's been a lot of developing technology over the last 20 years or so, but the formalities must still be complied with, otherwise it's possible that your deed particularly will be void. In the case of public authorities, they'll have some form of governance procedure about how their documents are executed. In the case of local authorities, it's a legal requirement to have contract standing orders. Meanwhile, the requirements for companies are set out in the Companies Act 2006. So how has COVID-19 complicated the execution of legal documents? There have been unprecedented restrictions which can be described as falling into two categories. Firstly, the difficulties in assembling paper copies of contracts and property deeds. And secondly, the issue around having signatories physically present with a paper copy in order to execute. Although there is technology available to allow electronic sealing, most public authorities are not set up to do this. So the next thing I want to touch on is the distinction between electronic execution and electronic signatures. Now, where I refer to electronic execution, it should more properly be properly called execution by virtual means. Electronic signatures go one step further, and apart from the next slide, that isn't the focus of this presentation. But just to go through the different ways that electronic signature can be obtained. And there are various different ways of doing this as set out on the slide. And some of them require certain technological solutions, where others require quite simple ways of doing this. That's the second one, about electronically pasting a copy in the form of a picture into an electronic copy of a document. The basis for this webinar is some Law Society guidance. So after the COVID-19 pandemic shut most offices, they issued a cover statement on the 7th of May, and there's a link there to their website where this statement is set out. But basically this confirmed earlier guidance that had already been given, confirmed that it had been reviewed and did not need updating. So what was this earlier guidance? This goes back to 2010 when they issued guidance note about effecting execution by virtual means, and the link to that is set out on the slide. More recently, they issued guidance around using electronic signatures. This was in 2016. There's also a Law Commission report on these issues. So turning now to the distinction between deeds and simple contracts. So the transfer, creation or disposition of an interest in land must be done by deed, and this goes back to the Law of Property Act 1925. Some contractual transactions also require use of a deed, particularly where there's a lack of consideration between all the parties, which is often the case where you have a multi-party document with at least 3 parties. Some property transactions can be done as a simple contract. So a license, for example, doesn't generally transfer, create or dispose of an interest in land. So what are the legal document formalities for simple contracts? Under the Companies Act 2006, simple contracts can either be signed on behalf of the company by someone with authority, or alternatively, the company seal can be used. So you have to bear in mind that these days companies are not required to have a common seal. Secondly, how can a public authority execute a simple contract? This will normally be set out in their governance arrangements. So, for example, signing underhand by an authorised officer or maybe two. A lot of local authorities prescribe in their contract standing orders that all contracts below a certain value are executed in this way. What about deeds? Well, for a company, again, this is set out in the Companies Act, and they can either affix their seal or signature on behalf of the company, confirming intention to execute as a deed by either two directors, one director and the company secretary, or one director in the presence of a witness. What about a public authority? In nearly all cases, local authorities execute deeds by affixing their seal, and their standing orders may prescribe how this has to be done and the circumstances of this. Other public authorities will have their own versions, and this may or may not require use of a seal. However, in many cases, this is simply a case of custom and practice, and the Law Commission in 1998 recognised that there was no legal requirement in the Local Government Act 1972 for a local authority to use its seal in order to execute as a deed. So, how to apply these formalities to the need to execute by virtual means? Now, this uses the Law Society guidance that I've already referred to from 2010. And just to explain that Law Society guidance followed a case called Mercury against HMRC. And this table on the slide is based on one that is set out on the Law Society website. So the Law Society identified a number of options or ways of executing documents by virtual means, and I've called these options 1, 2 and 3. And you'll see that option 1 is the only one that can be used for deeds. And as a firm, we're actually recommending option 1 is adopted by all our clients, whether or not they're executing a deed or not. One amendment I've made to this table is to add an extra row. So after deeds and real estate contracts, I've inserted contracts required to be executed by internal procedures as a deed or using a seal, just to emphasise that these types of contracts will reflect the same way as real estate deeds. So if a public body's procedures require execution using a seal, what can it do in order to follow option 1? So there are 3 possibilities as I've set out on the slide. Firstly, physical access to the seal and then printing. And this means that a page has to be printed, it gets sealed, it gets scanned back into an electronic document and then can be inserted electronically. What if you're an authority where the seal cannot be accessed because you can't access your office, but you can print? This may be where you have signatories who are able to print, but they're at home and unable to access the seal. So it may be that you can amend your governance procedures. So those 1 or 2 signatories can print the page, sign, scan it back in and insert electronically. You may, unfortunately, not be in a position to amend your standing orders, in which case, in order to execute as a deed, it may mean waiting until your offices are open again. So under option 1, how does this actually work in order to execute the legal document virtually? It's important to stress under option 1 that there has to be evidence of intention to execute that particular document. and this applies equally where there is sealing or whether there is signatories signing the document as a deed. It must be said that it does work best if you have the technology available to collate a single PDF of the contract. There are two basic methods for doing this: simultaneous execution and sequential execution. And where I refer to simultaneous and sequential, this relates to whether the parties are going to execute simultaneously or sequentially. On this slide, I've set up the process for simultaneous execution, and it needs the agreement of the execution's requirements and a lead solicitor. And you can see on this slide that I've set out the process. It does assume under the final step that it will be possible to compile a single PDF and then circulate that as the final document. So what is the most important element of that process? As I've said, you have to show this intention. So simply circulating a scan of a signed signature page is not sufficient. You also attach the final version of the document to show the required intention. Now, what if your file size is too big for one email? It's possible to send multiple emails of the document that needs to be executed, but it must be very clear in each email that every document is part of the wider document. I've set out an example there on the slide. Now, what about sequential execution? This is very similar and needs a lead solicitor, but it does mean that one party will execute, but then the document then comes back to that lead solicitor, and then this process is repeated with the second signatory. Again, a final version of the completed document is compiled and circulated. Important caveats I've already said about the whole document to be transmitted with the signature page each time, but there are other caveats as well. So where there are two signatures required for a single party, they do not have to be present together, but they must sign the same page. So between those two signatories, they can follow a sequential process. One director, for example, may send on to another, or one public authority signatory may send on to the other. Very important also that where one signatory is witnessing the signature of another, they must be physically present. So in the case of a company, this may mean the option of having a company director sign in the presence of a witness can actually be done, and it's better to use two directors. It's also the case that this process cannot apply to the execution of wills. It's also important to check the land registry rules, although at the beginning of May they announced that they would be prepared in most cases to accept option 1, known as sometimes as the Mercury rule in relation to the Mercury against HMRC case that I've already mentioned. You also have to check carefully about Companies House requirement, and particular attention needs to be paid to documents which must be presented to a notary and sent overseas. So just to conclude, what might happen after offices start reopening. It'll be interesting to see if this whole greater reliance on execution by virtual means will see a change in attitude and overall improved efficiency, faster execution. After all, you can do electronic execution by simultaneous means in an afternoon, and also the environmental benefits of printing less paper. It's also possible that public authorities and companies alike will move forward into an age of electronic signatures. And that's the conclusion of this webinar. I'd like to thank you for listening, and on the slide, some email addresses for further queries. Thank you for listening.